Good afternoon, everyone. This is the final of this year's Nuremberg Moot Court. I would first like to introduce the bench to you. On my far right is Judge Justice. To my right is Judge Chilstein. To my left is Judge Tusmuk Kamedov. And to the far left is Judge Peterson, and my name is Bertram Schmidt. I would like to first ask the parties for the appearances. We start with the prosecution, please. I would like first to know from you the appearances of you. Who comes for the prosecution? And then I give you the floor. So it's a little bit premature. Just introduce yourself and your colleagues for the record, and then I will give the floor to the defense, and then I will give you the floor for your submissions.
Mr. President, Your Honors, good afternoon. My name is Maria Rejevska, and together with my co-counsels Lydia Volkova and Maxim Vityuk, I represent the office of the prosecutor today.
Thank you very much. And then for the defense, please. Thank you very much. And where's your client?
Our client, Your Honor, is not present before this court, much due to our frustration.
Yeah. You know, normally hearings are held in the presence of the person concerned or the accused. There are instances where this is not necessary, and do you think we have such an instance here?
Not at all, Your Honor. Maybe it is the task of the prosecution to bring the accused who is to be charged, whose charges are to be confirmed today in front of this court. And the defense finds it very regrettable that he's not present in this case.
Mr. President, if I may, we just received a note that the defendant is kept in the sick bay at Scheveningen unit. Okay, so he could not be transported here.
Thank you very much for this information. This, of course, solves the problem, and I think furthermore we could assume that he has perhaps waived his right to be present. Thank you very much for this information, dear colleague. Then I give the floor to the Office of the Prosecutor for the submissions.
Mr. President, Your Honors, the system that hides the crimes committed behind the purpose of saving the country cannot remain unpunished. This case is of significant importance to be heard by this court, not only because it concerns the most serious crimes to the international community as a whole, but because it gives us a powerful demonstration that no one is above the law or beyond the reach of international justice. The prosecutor submits that, firstly, hearsay evidence is admissible before this court. There are substantial grounds to believe that Mr. Balboa is individually criminally liable as facilitator for, secondly, genocide, and thirdly, enslavement as a crime against humanity. And fourthly, there are substantial grounds to believe that Mr. Balboa is individually criminally liable as perpetrator by means for war crimes. With this in mind, and with your permission, I will proceed with the first issue concerning the admissibility of evidence. The court could rule on admissibility of all kinds of evidence. The prosecution submits that hearsay evidence, namely the interviews that were given by escapee workers about the overheard monoethnicity plan, which was adopted on the last closed meeting of DNP, is admissible before this court, since it meets all the requirements prescribed by Article 69 of the Rome Statute, as well as it satisfies the test which was developed by ICC in Lubanga case. Namely, firstly, this evidence is relevant to the present court, and secondly, it has necessary probative value. Evidence that is relevant makes the circumstances of the case more or less probable. Hearsay evidence is relevant since it contains essential information about the existence of monoethnicity plan, which could be used as a proof for the commission of the genocide. And as the genocide is one of the issues that are on the agenda on today's hearing, it is relevant to the present hearing. The second element of this test, probative value, exists if the evidence submitted by the prosecutor are mutually corroborative. This element is present since not only hearsay evidence, but also International Labour Organization reports and statements of DNP party could be approved for genocide. International Labour Organization reports state that ethnic minorities constitute the majority in the mines, and hearsay evidence proves us why. So this evidence submitted by the prosecutor have strong connection between each other. And the other element that may be assessed by the chamber, reliability, is present when the evidence are voluntary, truthful, and trustworthy. In the case under consideration, there is no information that workers were under the pressure while giving this evidence to the police officer. Moreover, there was no personal interest both for escaping workers and the guardian mines for telling irregular information. The guardian mines mentioned this monoethnicity plan during the private conversation, and they did not know that anyone could hear their conversation. The defense may argue that the only fact that these workers were ethnic minorities themselves could be a proof of the bias apprehended. However, the contrary submits that this only fact cannot be a proof, since firstly, these workers had no benefits from telling this irregular information to the police officers and media. And secondly, and what is the most important, they told this information to the police, and it's obviously that telling irregular information to the police is also a crime. Therefore, as a three-part test from Lubanga case is satisfied, as well as this evidence meets the requirements from Article 69 of the Rome Statute, namely relevance, probative value, this evidence could be recognized as admissible before the present hearing. And if the court has no questions about the admissibility of evidence, we would like to move to our second submission.
A quick question.
Yeah, of course.
Counsel, you said that the 10 escapees did not have any interest in giving their evidence. However, immediately after doing that, immediately after talking to media and police, they were transferred into the comfort of the then working hospital. Don't you find this to be an interest?
Your Honor, we submit that this fact that they were sick and traumatized and then transferred to the hospital prove us that they cannot establish some plan to say something bad about the government. This fact is not proof that they had the bias. And if I answer your Honor's question, I would like to move further.
I have also a further question. You referred to Article 69, and I would like to ask you, do we have any provision in the Rome Statute that requires a chamber to rule on admissibility with regard to the relevance of evidence?
Your Honor, in Article 69 of the Rome Statute, in paragraph 4, it is stated that the court may rule on the relevance of admissibility of any evidence, taking into account probative value and any prejudice effect.
Yeah. How do you interpret the word "the court may rule"?
The court had a possibility to rule. It's not a precise guideless how the court could rule on admissibility. The chamber have to decide which evidence are admissible or not, taking into account the Article 69.
Does the Lubanga test apply in all cases before the ICC, just if you know, by happenstance?
Your Honor, the test from Lubanga case come from the Rome Statute, from Article 69, and it also may be applied in all evidence that are submitted to the chamber.
You know, I don't see the wording of the Lubanga case decision in Article 69. And just as an information, also for everyone here in the courtroom, out of 3 ongoing trials at the ICC, 2 of them do not apply at all this admissibility standard. They do not decide on admissibility when it comes to the relevance of evidence at all. Just as an information, it's not a critique. It's, as I said, Article 69.4 clearly states may rule, There is an exception, though. There are instances where the chamber has to rule.
No, Your Honor. May rule means that the chamber not have to rule. It's to decide for the chamber what to do in this case.
Then, yeah, okay, thank you very much. Please proceed.
And I would like to move now to the second submission of the prosecution, namely that there are substantial grounds to believe that Mr. Balboa is individually criminally liable for crime of genocide. The prosecution submits that firstly, arrested persons forced to work in mines belong to an ethnic group. And secondly, Mr. Balboa had a specific intent to destroy in whole the ethnic group as such. We understand that the obligation of prosecutor is to prove all the elements of the crime. However, in the interest of time, we would like to focus only on these two elements as the most important for the present trial, for the present hearing, pardon me. Genocide requires that the acts prohibited by the Article 6 are committed against one of the four protected groups. Office of the prosecutor claims that arrested persons forced to work in mines belong to an ethnic group, since both subjective and objective criteria of identification is satisfied in the present case. ICC found in al-Bashir case that the group could be recognized as ethnic if it has its own language, customs, or traditional links to their land. Arrested persons perceive themselves as minorities since they speak the language of Mosul Federation, which is different from the Kar language. And this only fact of separated language could be a proof of their self-identification. Since, for example, in a Kayesu case, trial chamber rules that an ethnic group is generally defined as a group whose members share a common language or culture. Therefore, one language is enough to constitute the self-identification of the ethnic group. Moreover, Mr. Balboa divides this group of people from any other population of Nekar. DNP states in its public statement that ethnic minorities are traitors and ones whose unwillingness to support the political platform of DNP is one of the current reasons for the economic crisis in Nekar. Mr. Balboa, as the chairman of executive committee of DNP, had to be on the same position as his political party. Therefore, as the subjective and objective criteria of identification is satisfied in the present case, arrested persons were an ethnic group. They belonged to this group. Other core element of the genocide is specific intent dolo specialis to destroy in whole the ethnic group as such. Is there no precise fact in the facts of the case that the perpetrator or facilitator did have this intent? We can derive it from the circumstantial evidence or the general context in which the crime was committed.
If I may, counsel, if the intention was to destroy that group, which numbered in excess of 200,000, most of whom were employed at menial jobs in the mines, who would then work in the mines?
Could you clarify a question, Your Honor?
Does it make sense to destroy the group, the representatives of which do most of the hard work at the mines being one of the sources of income of the nation of Nekar?
Your Honor, it means that by diversion these workers, these ethnic minorities to mines, the perpetrator had the intent to impose on them conditions that will destruct them and damage them and bring physical destruction of this group. And we also submit that the mining sector wasn't really necessary to overcome the starvation and economical crisis in Nekar, because the Nekar was blocked by Mosul and they cannot sell or buy anything in this situation. Therefore, we submit this that the perpetrator imposes this condition to eliminate these ethnic minorities. And also, specific intent may be proved by the words of the perpetrator about the targeted group. For example, publicly associating this group with enemy in the war. Mr. Balboa has a specific intent to destroy in whole the ethnic group as such, because DNP party saw the ethnic minorities as secret agent of Mosul, therefore it publicly associated ethnic minorities with the enemy in this war. And it's commonly known that one of the aims of the DNP is to destroy the enemy to overcome the war between the Car and Moscow. Understanding this fact in conjunction with the monoethnicity plan, which was adopted on the last closed meeting of DNP, and with the information from international labor organization reports that ethnic minorities constitute the majority in mines, we submit that circumstantial evidence shows the clear intent of Mr. Balboa to destroy an ethnic group as such. Defense may argue that these actions cannot constitute crime of genocide, since they were directed against political opponents, as it was stated in temporary law. However, the prosecution understands that the political opponents is not one of the groups that are protected by Article 6 of the Rome Statute. However, DNP in its statement divides political opponents and ethnic minorities into two separate groups. And if the DNP shows these ethnic minorities as the political opponents, it wouldn't be necessary to divide them into two groups. Moreover, Mr. Balboa is a facilitator to the present crime because he is the chairman of DNP Executive Committee and chairman of the closed meeting of DNP, had the substantial power to facilitate the creation of UNICAR's policy for stabilization of economy and temporary law. This form of liability does not require the specific knowledge with facts about the crime committed, but general likelihood that his actions of facilitator will facilitate the commission of the crime. And also, it requires a special intent to destroy and hold the ethnic group, which exists in the Mr. Balboa actions. And if the court has no questions about the crime of genocide,
Counsel, one question is, in my mind, is that on the one hand, you're relying on this mono-ethnicity policy that you've asked us to accept as by way of hearsay. On the other hand, we have a facially neutral criminal statute that appears to apply to all 4 million people living in Neckar. And we have a statement from the government saying that they have no mono-ethnicity policy. How should the court deconflict two versions of events which are opposite?
Your Honor, we understand your concern, and we know about the statements of DNP parties. They rejected that they have such a mono-ethnicity plan. However, we submit it's when the DNP party established that they had mono-ethnicity plan, they will be liable for genocide. They are biased in this purpose to tell they had or know this mono-ethnicity plan, and our evidence, our charges are not based only on the hearsay evidence. This evidence corroborates with the statements of DNP and the International Labour Organization reports. And if the court has no questions about the genocide...
I have a further question, unfortunately, I have to say. About what mode of liability are we talking here? Because you're speaking about facilitator. What facilitating? What kind of mode of liability should that be? Where would we have to group that in?
Your Honor, we submit that Mr. Balboa is liable both for crime of genocide and crime of enslavement as the facilitator, because he carried acts to facilitate the commission. He lent the moral support to commit this crime.
But if we are looking at Article 25, 3c, I think it's talking about for the purpose of facilitating, and then then afterwards we hear about some sorts of modes of liability, aiding, abetting. You see what I mean? So for the purpose of facilitating is a special intent that is required for this mode of liability. So do you submit that the charges are about aiding or abetting, or?
Exactly, Your Honor. We submit that we charge Mr. Balboa with aiding and abetting, but as the mental element of the aiding as abetting is the purpose of facilitating, we say that he was a facilitator to the present crime. And I would now move to my third submission, namely that there are substantial grounds to believe that Mr. Balboa is individually criminally liable as facilitator for enslavement. We submit that all the elements of crime prescribed by Article 7.1c of the elements of crime are satisfied, but we would like to focus only on the one element that is the most important to the present submission, that the attack includes exercising the powers attaching to the right of ownership. Prison labor as forced labor as a penalty is not mentioned in the Rome Statute. However, enslavement, in the meaning of Article 7.1c, it covers not only slavery in traditional sense, but also the range of slavery-like practices such as forced labor or debt bondage. Exercising the powers attaching to the right of ownership is present when the perpetrator, among other acts enlisted in Article 7.1c, imposing on the victims similar deprivation of liberty. Back to the Nuremberg jurisprudence, International Military Tribunal in Pole case ruled that compulsory labor constitutes slavery, and I'm quoting here that slavery may exist even without torture. Slaves may be well fed, well clothed, and comfortably housed, but they're still slaves. If without lawful procedure, they are deprived of their freedom by forceful restraint. In this case, we submit that reversion to mines constitutes enslavement because the perpetrator exercised the powers attaching to the right of ownership and imposing forced labor over minors. It's because, firstly, the law on basis of which these workers were derived to mines was based on the violation of human rights. This law violated human rights. And according to Article 21.3 of the Rome Statute, the application of law must be consistent with internationally recognized human rights. The restriction of freedom of movement and freedom of expression is not necessary in democratic society because it not corresponds with the present social need and it's not justified with legitimate aim pursued.
If I may.
Yeah, of course.
Counsel, it appears that the state of Neckar has been engaged in an armed conflict with Mosul Federation for quite some time now. You know that ICCPR as well as European Convention, they provide for a derogation from rights and freedoms in cases of emergency or other crises that would endanger the nation. We don't know whether the state of Neckar declared that derogation. We don't know even if Neckar is a party to ICCPR, but don't you think, apply your imagination, that the temporary law that we're talking now was adopted as part of a derogation process for the period of crisis? What would be your take on that?
Your Honor, we understand that in some cases the human rights could be violated, but not in this particular case.
I'm saying derogated from.
Sorry?
I didn't say violated, I said derogated from.
Thank you, Your Honor. It is stated in the facts of the case the DNP had two main goals in its political platform: to overcome the starvation and to the end war between Neckar and Mosul. But by establishing this policy and diverting people to mines, they cannot reach these goals necessary for the society of Neckar. Because, firstly, the war can be won not with army of miners, but with army of soldiers. And we draw the attention of the court that the car was blocked by the Mosul, and they cannot buy the iron or sell the iron and give a benefit from this. And these actions of diversion people to mines had the benefit only to the DNP and Mr. Balboa personally, because he had the first labor in his mines, and the DNP had all the political opponents imprisoned in the mines and destroyed these political opponents. And we draw the court attention to the two positions of authority of Mr. Balboa in high-tech mines and high-tech IT corporations and DNP, and that he divided these people into three separated groups, which can gain the benefit only to Mr. Balboa, not to the nation of Neckar. And I would like to move now to my final submission, that there are substantial grounds to believe that Mr. Balboa is liable also for war crimes. Before going to the specific arguments of the case, we'd like to stress the relevant facts. Mr. Balboa, being chief executive officer and major shareholder of high-tech IT corporation, orders his team to hack into the computers of hospital and both shut down all medical equipment and turn off the electricity supply. we submit that all the elements prescribed by elements of crime are satisfied in the present case. Mr. Balboa directed an attack. The attack took place in the context of war, and Mr. Balboa intended civilians and civilian population to be an object in this attack. Cyber attack is new development of technologies, and drafters of 4 Geneva Conventions did not have them in mind while drafting respective treaties. However, cyber attack could constitute attack under Article 49 of the Additional Protocol to the Geneva Convention and trigger the application of international humanitarian law if it suits the definition of the attack as it is prescribed in Article 49 of the Additional Protocol.
Counsel, for me, Counsel, please convince us that cyber attack would be equal to kinetic attack in the sense of Geneva Conventions and the additional protocols.
If it's acted in violence against the adversary, whether in offense or in defense, this attack, cyber or not, it would constitute the attack under meaning of the Geneva Convention and Rome Statute. And also, Otto Triefturer in his commentary stated that cyber attack could constitute an attack if it caused the damage to the civilian population.
Can you rely on any sources other than the Geneva Conventions, sources which are contemporary and can deal specifically with cyber warfare?
Your Honor, we rely on the definition of the attack under Geneva Convention and to the statements of Otto Triefturer, that a prominent scholar in the field of international criminal law.
And at least we have some death here as a consequence of the cyber attack, so this could be perhaps an argument to at least qualify it here as an attack in that sense.
Your Honor, submits that the reason of the result of this attack was 45 dead people. Therefore, it caused the damage to the civilians. And also, we submit that this act took place in the context of war and was associated with an armed conflict between the car and Mosul. It is a fact that this conflict between the car and Mosul exists. And we acknowledge with that fact that the only existence of an armed conflict cannot be proof of the war crime, but also, as was stated in Katanga confirmation of charges, it's not necessary to a war crime to take place in the middle of the battle. And we submit that the war played a substantial role in the decision of the perpetrator to commit the attack, because firstly, it was in the territory of the enemy who was in the car, Mosul, and secondly, the intent of Mr. Balboa was to destroy the workers that could gain the advantage to Mosul in this war between two states. These workers can hold the government of Mosul about the violation of human rights, about the real situation in the car. And it can give the Mosul advantage as a country who fighting against the Nakar who violates human rights. And also, we submit that Mr. Balboa is liable for this crime was under Article 25(3)(a), since he used high-tech IT corporation team as an instrument to commit the objective elements of this crime. And he also liable under Article 25(3)(b). May I just finish my sentence?
Just the sentence, please, because we have to be on time.
Since he instructed person to commit objective elements of the crime, being in position of authority. Thank you for the attention. We invite this court to confirm the charges against Mr. Balboa.
Thank you very much. It was remarkable that you were able to go through all the important and relevant legal and factual questions with regard to all the questions that have been put to you from the bench. Thank you very much. And now I give the defense the floor, please.
Good afternoon, Mr. President, Your Honours, and may it please the Court. The defence requests the Court to decline the charges made against Mr. Balboa. I will prove firstly that the evidence introduced by the prosecution is inadmissible before this Court, and secondly, that Mr. Balboa, a man who has been painted by the prosecution as a ruthless criminal, is not responsible for the aiding and abetting of genocide under Article 6C. Subsequently, my co-counsel
will additionally prove that he can also not be held responsible for the charges of crimes against humanity and war crimes. Your Honours, this case, particularly the charge of genocide brought by the prosecution, rests primarily on one single piece of evidence, namely the testimony of the police officer relating to the alleged monoethnicity plan adopted by the DNP executive in their closed meeting. It will be shown that this testimony is inadmissible pursuant to Articles 69(2) and 4 of the Rome Statute, and admitting it would patently violate the right to a fair trial as codified in the Principle 5 of the Nuremberg Principles. As stated in the Lubanga decision, paragraph 24, when assessing the admissibility of evidence, this chamber shall weigh the competing probative value and the prejudicial effect. Therefore, my argument rests on two pillars. Firstly, the low probative value of this evidence will be demonstrated. And secondly, the excessively high prejudicial effect of the evidence will be proven, and that taken together, it renders this testimony of the police officer inadmissible. In relation to probative value, two things become apparent. Firstly, as is clearly established before this court, as for example in the Bemba decision, paragraph 51, hearsay evidence carries an inherently lower probative value. In the case at hand, the evidence constitutes anonymous third-degree hearsay evidence, and therefore the probative value must be substantially lower. Also, the evidence in question cannot be corroborated, as there is no other evidence introduced by the prosecution relating to a monoethnicity plan allegedly adopted by the DNP Executive Committee, and therefore, because of its anonymous hearsay nature, it cannot be considered before this court as established in the Mabrishmana decision, paragraph 49. When weighing this very low probative value in relation to the prejudicial effect, again, two things become apparent. Firstly, the defense has not and will not receive the opportunity to examine the deceased witnesses. Additionally, the evidence in question goes directly to the acts and conduct of the accused as it relates to a meeting of the DNP Executive Committee chaired by the accused pursuant to paragraphs 1 and 13 of the case facts. Therefore, pursuant to Rule 68, 2C2 of the Rules of Procedure and Evidence, this may constitute an additional factor speaking against the introduction of this evidence.
But since you are mentioning Rule 68, 2C, what perhaps for the audience here, what does it provide for in principle?
In principle, Your Honour, it provides for cases in which the witnesses giving the testimony are deceased, and even if the court thinks that this does not immediately apply, as indeed the testimony introduced here is of the police officer, also Rule 68 2b refers to the acts and conduct of the accused.
Yeah. But when, as we have to assume, because it's the wording of Rule 68 2c, this provision says that in case a witness has deceased, it is possible for the chamber to introduce the former record of a testimony into evidence. So don't you think this could be also an argument to say that you can then at least also listen to the person who has questioned at the time the deceased witness? Wouldn't you think that would be in a system that would fit together?
Well, Your Honour, the defence does not dispute that this is indeed a valid argument. However, there still needs to be a minimum standard of reliability that this evidence ensures, and additionally, it shall not be prejudicial to the rights to defence. And since, as the prosecution has established, this evidence is so relevant and close to the acts and conduct of the accused, it would irreversibly prejudice the rights of Mr. Balboa.
And exactly which right? Of course, it's apparent, but I want to hear it from you.
Well, Your Honour, for example, as in Article 67 1e, the defendant has the right to confront and examine witnesses testifying against him or her. And in this case, at hand, an examination of the police officer would not be effective, as he cannot testify in any different way to the content of what was mentioned by the deceased witnesses, Your Honour.
That of course is true, but I don't want to insist on that. But since such a provision as Rule 68(2)(c) exists, there seems to be at least some possibilities, legal possibilities, to introduce evidence into the record that cannot be questioned. But please continue. You have also referred to the low probative value of such evidence. Please continue.
Thank you, Your Honor. Now, taking all the previous factors mentioned together, the defense once again reiterates that this evidence should not be admitted before this court. And if I may now, I will move to the charges made against Mr. Balboa, more specifically the charge of genocide. Here, I will make 3 submissions. Firstly, that the contextual element is not fulfilled. Secondly, that the conditions imposed were not calculated to bring about the physical destruction of the group pursuant to Article 6C. And third, that Mr. Balboa did not meet the requirements under Article 25(3)(c). Firstly, in relation to the contextual element, it was established that for this to be fulfilled, there must have been a manifest pattern of similar conduct or conduct that can in itself affect the destruction of a group. Now, the requirement, particularly the requirement of manifest, was clarified in elements of crime in the introduction of Article 6, namely Article 6b, that manifest is an objective qualification. This was further concretized in the arbitrary arrest warrant decision, paragraph 124, where it was stated that there must be a concrete and real threat, not a hypothetical and latent one. Now, the prosecution has failed to establish that the contextual element was indeed fulfilled, and the submission of the defense is that there is no evidence that there was a concrete and real threat to the existence of the Mosul ethnic minorities. Excuse me. Moving to my second submission, namely that the conditions imposed were not calculated to bring about the physical destruction of the ethnic minorities. It was stated in the Ptolemy Appeal judgment, paragraph 233, that this crime covers methods of physical destruction other than killing, whereby the perpetrator ultimately seeks the death of the members of the group. Now, here one has to mention the Karadzic judgment, where the facts of the case were quite similar to what we have in front of us today. The Bosnian Muslims and Bosnian Croats were detained under deplorable conditions, inadequate hygienic and sanitation facilities, improper nourishment, forced to work, and additionally they were sexually abused and beaten regularly. Now, in that case, the court, although acknowledging that these conditions were atrocious conditions to be held under, said that this does not prove that the conditions were imposed with the deliberate aim of bringing about the physical destruction of this group. And therefore, Your Honours, it is submitted that in our case, where we have less evidence even, it is not enough to establish that the conditions were imposed to bring about the physical destruction of the group. Moving to my third point, namely that Mr. Balboa does not fulfill the requirements of aiding and abetting under 25(3)(c), the prosecution has conceded that to be held responsible as an aider and abetter of genocide, Mr. Balboa must have held the genocidal intent. Although the defense acknowledges that there has not been jurisprudence of this at the ICC as the only genocide case that has been brought before the ICC is currently at the arrest warrant stage and does not deal with the mode of liability under Article 25(3)(c), one can resort to other international case law, such as the case law of the ICTR, where there's consistent case law indicating that a dolo specialis is indeed required to be held responsible as an aider and abettor to genocide. This is, for example, the Akayesu trial judgment paragraph 485, the Nakatoritama appeal judgment paragraph 787, the Nadimana appeal judgment paragraph 157, and the Rutakanda appeal judgment paragraph 530. It is...
Counsel, one question. if that is your submission, how would the defense then, for example, distinguish an aider and abettor from a perpetrator of genocide if they both have to have basically the same mens rea?
Well, Your Honor, aside from the fact that the prosecution has argued explicitly that he must fulfill the purpose of facilitating the crime additionally to the genocidal intent, the defense submits that the mens rea requirement under Article 25.3c has been interpreted in the Mabrishimana pretrial confirmation of charges, paragraph 281, and I quote from this judgment, if I may, saying that the jurisprudence of the ad hoc tribunals does not require the aider and abettor to share the intent of the perpetrator to commit the crime, whereas under Article 25.3c, the statute, the aider and abettor must act with the purpose of facilitating the commission of the crime. So the court has in its jurisprudence clearly distinguished between the requirements of the ICTY and the requirements of the ICC when it comes to aiding and abetting, and has very clearly set at a higher threshold altogether. And therefore it is submitted that at the ICTY and at the ICTR, where we have a lower threshold for aiding and abetting already, which is merely the knowledge of the principal perpetrator's intent, this court should determine that at the ICC, where the threshold is higher, and for the crime of crimes, that is genocide, that the aider and abettor must share the principal intent, namely the dolus specialis. It is submitted that in our case there is no evidence that Mr. Balboa held such an intent. The prosecution has tried to make a case that because the majority of the workers in the mines were of the nationality or of parts of the ethnic minorities, and that allegedly he was present when this mono-ethnicity plan was adopted. It is very clear in previous genocide cases at international tribunals that this does not suffice to establish dolus specialis, as very clearly stated in the Nahimana et al. Trial judgment, paragraph 524. The finding of such an intent must be the only reasonable inference from the totality of the evidence. And in Mr. Balboa's case, it is admitted that, on the contrary, he's profiting economically from having these workers work at his mines, and it would be contrary to common sense for him to intend for the destruction of these ethnic minorities. If your honors have no further questions on my submissions, I would hand over to my colleague, Ms. Mills.
Thank you very much.
Thank you.
Good afternoon, Mr. President, Your Honors, and may it please the Court. On behalf of the defense, I will now demonstrate that Mr. Balboa is not responsible for the crime against humanity of enslavement as an aider and abettor, and not responsible for the war crimes of attacking civilians and civilian objects. Concerning the crime against humanity of enslavement under Article 7.1c, the defense will make two submissions. Firstly, that the conduct in question did not constitute enslavement, and secondly, that in the alternative, Mr. Balboa is not responsible as an aider and abettor under Article 25.3c. Turning to our first point, that the conduct did not constitute enslavement, the forced labor, as charged by the prosecution, is not, I will demonstrate that forced labor, as charged by the prosecution, is not present in our case. It was stated in the Knoyalat's appeals judgment, paragraph 200, that work required of a person in the ordinary course of lawful detention is not to be regarded as forced or compulsory labor. The prosecution has mentioned the Paul case of the IMT, and referring to this case, it also states that that people would not be considered as enslaved if they were deprived of their freedom through a lawful process, as opposed to forceful restraint. I will now demonstrate that in our case, we have lawful detentions, as firstly, as you can see in paragraph 6 of the case facts, all perpetrators of minor offences were diverted to work in the mines, and there is no doubt that they were lawfully detained and therefore not forced to work. Now, regarding the persons that were charged and had violated the temporary law, firstly on that matter, I would like to respond to the question by your judges regarding the temporary law and whether it could be, in this time of crisis, possible that NECA derogated to the freedom of expression. And indeed, it is stated in the ICCPR Article 4 that in time situation of emergency, a state could derogate to the right of freedom of expression, which in our situation we have, as the temporary limits the freedom of expression. But in any case, whether this goes against human rights doesn't mean that it amounts to a crime against humanity. So the persons that had violated this law were then charged and put to work in the mines. Now, this means that they were suspected criminals. And if we look at the European Convention of Human Rights, it defines lawful detention as the lawful arrest or detention of a person on reasonable suspicion of having committed an offense. Your Honours, it is submitted that in this situation, convicting those, requiring those suspected criminals to work in the mines would not amount to forced labour.
Okay. May I shortly, would you qualify any law in any country as a, and afterwards detention when a person has not fulfilled the requirements of the law, would you qualify this in any event as a legal detention then? Looking especially at the specificities of the temporary law, Article 3, Paragraph 1, Article 4, Paragraph 1.
Your Honour, lawful detention is based, according to the Knoylat trial judgment, Paragraph 122, as detention based on legal basis under national law. Therefore, it would be in our situation the law of NECA that would determine whether this law is unlawful. It might go against human rights, but in our situation it doesn't mean that it would amount to a crime against humanity.
So a completely formal position you take in that regard?
I'm sorry, Your Honour?
You take a formal position in that regard. If there is a law and if it prohibits a certain conduct, and then it is lawful according to the national law, and that is enough to qualify it or to disqualify it for being a crime against humanity. Do I understand this correctly?
Yes, Your Honour, because it would not amount to forced labour, as labour required of lawful detention would not amount to forced labour. And this view is supported by the Knoylat's case, trial judgment, Paragraph 121, when they determined whether the non-Serbs were lawfully detained or not. They not only looked at whether they were convicted criminals, but also as whether they were suspected.
Counsel, it looks like there's some confusion. You were referring to the European Convention on Human Rights and Fundamental Freedoms as allowing a detention of a person suspected of committing a crime, pending his or her appearance before the court of law and pending a judgment. Now, here we have a law which allows to convict a person based on suspicion. Do you feel the difference between the provision in the European Convention and in temporary law of NECAR?
I'm sorry, Your Honour, could you repeat your question?
Let's move on. Thank you.
If Your Honours allow, allow me, I will now turn to...
Please proceed, it's okay.
I will now move to my second point, that if the court were to find that a crime against humanity of enslavement would have occurred, in any case, Mr. Balboa is not responsible as an aider and abettor under Article 25.3c. Under this mode of liability, two requirements must be fulfilled. Firstly, the perpetrator must aid and abet the commission of the crime, and secondly, act with the purpose of facilitating the crime. Concerning the first requirement, the prosecution has brought forward that Mr. Balboa facilitated this crime by lending moral support, if the defense understood correctly. However, in our situation, there is no evidence that Mr. Balboa affected any moral support of any kind in the case facts at hand. Turning to his purpose, the prosecution has also not clearly delineated how Mr. Balboa contributed to this crime, and the defense would like to highlight here that the requirement under this article is that of purpose of facilitating the commission of the crime, which is a higher requirement than Article 30, according to Bemba et al., and means that the perpetrator must act with the intent to facilitate the commission of the crime, as stated in Blé-Goudet decision, paragraph 167. So in our situation, similarly to the Rush case in front of the IMT in Nuremberg, Mr. Balboa, from his position as CEO, maybe knew of what was happening, but this does not mean that he acted with the requisite mens rea. Rather, there are no facts to indicate that he lent his assistance with the intent of facilitating the crime. If the court were to find that he contributed to the crime, this doesn't mean that by going to his day-to-day business activities, he facilitated the commission of such a crime, and that he intended the facilitation of such a crime. Therefore, it is submitted that Mr. Balboa did not contribute to the crime through moral support, nor did he act with the purpose of facilitating the commission of the crime, and therefore is not responsible as an aid and abettor. And in any case, the conduct in question did not constitute enslavement. Turning to our second submission regarding the war crime, the defense will make one point, that the conduct was not associated with the armed conflict. Mr. Balboa, reacting impulsively as a response to the lies spread by the escapees about the alleged forced labor in his mind, made the regrettable decision to shut down the equipment of the hospital. However, Mr. Balboa acted for his private business, and thus the conduct had no link to the armed conflict, and it cannot be therefore a war crime under Article 8. Indeed, according to the elements of crime, what is needed for conduct to be a war crime is that it is associated with the armed conflict, meaning closely related to the hostilities, according to Lubanga decision, paragraph 288. The prosecution has referred to Katanga trial judgment, saying that it doesn't need to be in the midst of the battle to be associated with the armed conflict. However, it failed to mention paragraph 1176, which states that the armed conflict must play a substantial role in the decision and ability to commit a crime. And to assess this, one can take into consideration, firstly, the status of the alleged perpetrators, and secondly, whether it served the goal of military campaign, according to Bemba trial judgment, paragraph 143. Relating to the first indicator, the status of the alleged perpetrators, it is also stated in Rutaganda Appeals, paragraph 570, that particular care is needed when doing this assessment when the perpetrators are non-combatants. So here, Honours, this is exactly the situation we are in, as Mr. Balboa, the alleged perpetrators, Mr. Balboa and the hackers were not combatants, rather they were civilians, as defined under Article 50, paragraph 1 of Additional Protocol 1. And secondly, with regards to the second requirement, the second indicator, whether it served the goal of military campaign, as already stated, Mr. Balboa acted for his private business to protect his company and to protect his honor. And there's no link to a goal of military campaign, and the fact that attacking the hospital did also not provide a military advantage further evidences that. Lastly,
Counsel, one question on the nature of the protected site, the hospital. Would the defense concede that had Mr. Balboa been in a military command position, it would have been unlawful for him to direct an attack against a hospital?
This is correct, Your Honor. The defense concedes that this was an attack against a civilian object.
Okay. So your argument rests upon the lack of linkage between a war campaign and his act as a private citizen.
Yes, Your Honor, but I could also respond to the arguments made by the prosecution regarding the cyber attack, but in view of the time, I now only address the nexus to the armed conflict.
But I think the time is over, so to be fair to all participants, and as I have learned as a civil law judge from common law, that equality of arms is very important. This also means equality of the time allotted, so we have to stop here then. Thank you very much.
Thank you, Jonas.
And I give now the floor again to the prosecution for a 5-minute rebuttal.
Mr. President, Your Honors, the prosecution has 3 small points for the rebuttal in response to the submission of the defense. Firstly, about the admissibility of evidence. Secondly, about the specific intent of Mr. Balboa. And thirdly, about the charging of crime of enslavement. Defense argued in her submission that we cannot find the first source of evidence and could not question this source. However, I would like to stress on the procedural aspects of the hearing in pretrial chamber in the confirmation of charges. It is stated in Article 61 of the Rome Statute that for this proceeding, pretrial chamber proceeding, it's not needed to call the witnesses and to question these witnesses and cross-examine their testimonies. Even if we could and we needed for this stage of proceeding to question these workers, we cannot do this because the defendant, Mr. Balboa, orders a check on hospital and kills these workers in this hospital. Moreover, for example, in Milosevic case, ICTY already stated that hearsay evidence of those statements made by others is admissible before the chamber. Moving to the second element of the rebuttal, the second point of the rebuttal, we submit that the genocidal intent was in the actions of Mr. Balboa. It is stated in case of Kashema and Rosidana that it would be hard to prove this specific intent to destroy in whole the ethnic group as such. It can be proved by circumstantial evidence. And we also would like to rely on the procedural aspects of the pretrial hearings, that we just need to establish substantial grounds to believe that the perpetrator or facilitator is liable for such crime. And according to the third point for the rebuttal, the defense argues that the detaining of the workers was lawful and in accordance with law. However,
may I shortly, you correctly mentioned, and I'm happy that you did that the evidentiary threshold that we here have to consider is substantial grounds to believe. What do you understand by that? How high is it? How low is it? Is this evidentiary threshold?
Your Honor, substantial grounds to believe is higher than reasonable grounds to believe that it was in warrant of arrest, but is lower than beyond the reasonable doubt that it may be established in the trial chamber. And according to our third point of the rebuttal, we submit that the temporary law not even prescribes that the people who violate this law may be detained to mines. It is stated that people who violate this law must be rehabilitated or imprisoned, and we submit that rehabilitation in this law cannot mean the working in mines. Because, for example, in International Labour Organization Convention on Forced Labour in Article 21, it is stated that forced compulsory labour shall not be used for work underground in mines, which proves that subjecting people to work in mines cannot be justified by any reasons, even the reasons of overcoming the economical crisis and war. And to prevent your Honor's question, we can use this International Labour Organization Convention as a source of law because the elements of crime give us a possibility of such. It is stated in the note to Article 7.1c that the deprivation of liberty could constitute forced labor as defined in Supplementary Convention on Abolition of Slavery. And in this convention, in its preamble, it is stated that the provisions of the forced labor were drafted in respect to Forced Labor Convention on 1930. Therefore, this convention is applicable, and the working underground in mines cannot be justified by any purposes. And moreover, these persons were just suspected and charged in the crimes committed. They were not lawful procedure, and the court to submit that they were guilty of these crimes. If the court has no further questions to the prosecution, it concludes our rebuttal. Thank you for the attention, and may it please the court.
Thank you very much, and I now give the floor for the defense for rejoinder. If you may.
Good afternoon again, Mr. President, Your Honours, and may it please the court. The defence will now respond to two of the points made by the prosecution in its rebuttal. Contrary to what has been alleged, the evidence is not admissible. Now, the prosecution has alleged that the standard of proof is different, and that additionally the hearsay evidence should not be inadmissible per se. Excuse me. Now, what is important to state here is that a lot of the conditions that make this evidence inadmissible will not change when moving on to trial. Now, one of these very contentious points is that the evidence is anonymous hearsay evidence and not merely hearsay evidence. Since the actual original source of the evidence is unknown. Now, the prosecution has in no way demonstrated that it will make an effort to discover the original source, nor has it made an effort to locate the guards that made the statement originally overheard by the deceased witnesses. Therefore, the defense admits that there is no view that the conditions rendering this evidence inadmissible will change for a trial, and the deceased witnesses will not come back to life for the defense to examine them. Additionally, reference was made to ICTY case law, which is very clearly stated, as in the Ruto and Sang decision paragraph 58 or Bemba decision paragraph 41, cannot be compared to ICC procedural regimes, as the procedural regimes of the ad hoc tribunals in the ICC are, and I quote, fundamentally different. Additionally, in relation to my second point, which relates to the allegation that Mr. Babawa did possess the dolus specialis, the defense wants to make clear that, as stated in the Blagojevich and Jokic trial judgment paragraph 656, also the Kristich appeal judgment paragraph 595, a general awareness of the probable consequences of a genocidal act is not sufficient to prove genocidal intent. And additionally, as stated in the Rutaganda appeals judgment paragraph 528 and Mladic trial judgment paragraph 3457, the approach that evidence may be inferred from the overall contextual situation does not mean that the guilt of an accused may be inferred only from his affiliation with a guilty organization. Now, while it may be true that the DNP perpetrated crimes, this does not mean that Mr. Babawa, as an individual, is guilty for such crimes. If there's no further questions by this bench, this concludes the submission of the defense, and I would like to reiterate that we request this bench to decline the confirmation against Mr. Babawa, as contrary to what has been stated by the prosecution in relation to the standard of proof, what is actually required at this stage of the proceedings is, and I will again quote from a judgment, is that the prosecution, as stated in the Lubanga confirmation of charges, paragraph 38, and the Katanga confirmation of charges, paragraph 65,
must present concrete and tangible evidence which demonstrate a clear line of reasoning underpinning its specific allegations. The defense admits that this has not been done. Thank you.
Thank you very much. This concludes the submissions of the parties. The chamber will now retire for deliberations. I would request everyone here in the courtroom not to go too far away, to stay close, so to speak, and we will announce in due course our judgment, so to speak.
Order!
Please be seated. So the exciting moment is now here and there. We had, I think, quite an active bench here. This was not to make you in any form insecure, but it's simply how life is in a courtroom. It's not always a comfort zone to be in a courtroom, to be pleading and to speak to judges. And it was very helpful, your answers to the questions that were put to you. The chamber recognizes especially the stamina of all of the teams, especially those who have been present. My colleagues in the past days could assure me that it was very, very tough, and at the end of such a tournament, so to speak, to be so great in your submissions is really something that cannot be evaluated high enough. What I personally would like to encourage everyone in the courtroom, and also, of course, the teams here, I think what has been at least been shown in the past 1 hour is that it is very important not only to be knowledgeable when it comes to the legal requirements, but also to the factual assessment of evidence. Because no case is like the other case. It all depends on how the facts are. It all depends on how the legal requirements can be proven or not be proven, or disproven. So just a very short example. We have heard a lot about hearsay, but not all hearsay that we had here in this case was equal, so to speak. It is a difference if we have people who have talked to a police officer and then died, or we have a police officer telling about what people told him about what other people have told them. So there are different gradations of evidence, and they have to be, of course, evaluated and assessed differently, and they have a different probative value. Also, what I would like to mention is that all these reports are also hearsay evidence, of course, yeah, so to speak. But I don't want to dwell into that further. The chamber had a big difficulty to really come to a conclusion here, and this is clearly shown by the fact that we were not unanimous. It wasn't a majority decision, so to speak. It was tough, extremely close, tight, so to speak, but at least we had to come to a conclusion, and with majority we came to the conclusion that Maastricht has won the term. And for once, I'm happy to really be able to say that it was a majority decision. In Germany, it would not be allowed at the Supreme Court, where I was initially coming from. We would always have to pretend that it was unanimous. But here, I'm happy that we don't have to pretend to do that. We have, though, also to qualify a person as the best speaker. And here we came to the conclusion that Maria Rajewska was the best speaker. not because Ukraine as a team was really so closely to the winning team, but we thought that especially how you reacted to the questions, and also the fact that you spoke 30 minutes, you had the whole burden on yourself. We thought that this would qualify you for the best speaker, I think, which is also. And the second best speaker we thought would be Victoria Maria Heberle. And thank you very much, everyone. I think everyone will hopefully stay for the ceremony, and then there will be further words I will say to you that I really have, that I really want to. And we finish that for the moment, and please stay here and by that also honor the two teams and everyone who has participated. Thank you very much.